You were on bond for this DWI since 2019. You took off. We haven't seen you since 2019. And the only reason we have you here now is because you have a home improvement fraud case from Louisiana.
I came in to pay for my DWI, Your Honor.
When?
That's why I'm here.
Oh. You got another case now.
Say again?
You have a new case now.
Yes,
We filed a fugitive case against you. I don't know anything about it. All I know is that you have an open DWI with us. You have a prior fugitive case, and now it's another fugitive case.
Bailey Sagal walked free that morning. Kareem Williams did not know he had already lost the argument to a stranger's criminal record. In a Harris County courtroom, a prosecutor stood up and read out a rap sheet soaked in violence, burglary, stolen property, a felony weapons charge, battery, child endangerment. She said it belonged to the man standing in front of the judge. He said it belonged to someone else entirely. And for a few tense minutes, nobody in that room could prove who was right. This is the story of how a bond hearing almost punished the wrong man for crimes he never committed, and what it reveals about how easily the system can get it catastrophically wrong. Kareem Williams had been sitting on an open DWI driving while intoxicated since 2019. A warrant for his arrest had been issued that July, and for 4 years the case simply sat there, untouched, while Williams says he tried to move on with his life.
No, there was a warrant issued on July 31st of 2019 for your DWI.
He was only back in front of a judge now because of an unrelated case out of Louisiana, a home improvement fraud allegation tied to his construction business. Fraud charges like that typically require proof of intent to deceive, not just a failed project or a licensing dispute, and Williams's attorney argued this was closer to a civil contract disagreement than a crime.
It was dismissed. The case was dismissed by Louisiana. The DA didn't even take the charges.
They did file dismissal on that.
Yeah,
for whatever reason it was.
The whole time, that's why, because you guys asked me to report whenever it was dismissed, and we just went. I had an attorney out there. I gave him my attorney's number. She fought back and forth, and the DA didn't even accept the charges. That's why it was dismissed.
Judge, I would argue that shouldn't be considered against him if that's the case.
He still has a prior fugitive case, right? I mean,
Well, just talking about this one, he's saying he had no knowledge of the filing of this case. This is called a home improvement fraud. It sounds like from talking to him, this is leaning, my argument would be this is leaning more towards a civil matter than a criminal matter. He works as a construction builder. He has his own company, my understanding. He is on the minority builders list for Harris County. And so he's got a company. It sounds like this might be
cases where a guy takes money to build a house or make improvements and then they boom, just take off?
No, what happened was it was a licensing. Oh, I'm sorry.
It was a licensing. He's talking about a licensing issue. I don't want to get into the specific facts of that, Judge, but on these construction projects, there's always 100 lawsuits that could pop up, and some of those can turn criminal. And so he is looking for an opportunity to fight that over there. But
intent is exactly what prosecutors would soon claim to see everywhere.
He's got a lawyer by the name of Jeanette in Louisiana that's going to help him resolve that situation. His DWI here is being resolved by Mr. David Brazil. All we ask is for him to be able to post a bond so he can go figure out Louisiana, turn himself in or post a bond out there and resolve the case instead of having to wait for Louisiana to come get him.
Because moments later, the prosecutor dropped a bombshell. She told the judge that Williams had a violent criminal history out of East Baton Rouge, Louisiana, looting.
Judge Fletcher, just based on his warrants that were issued on the DWI case local here in this court, and then the 2 warrants issued for his last fugitive case, and then further criminal history out of East Baton Rouge, Louisiana for looting, burglary,
possession of stolen
property, damage to property, possession of stolen property, MJ felony, theft, monetary instrument abuse, battery, child endangerment.
Judge.
That's not me.
Are we sure we're talking about the right Kareem Williams?
Kareem Williams.
Burglary, possession of stolen property, a felony weapons charge, battery, child endangerment. The kind of list that, if true, would make bond nearly impossible to justify. The judge, weighing whether to release him, was staring down a record that painted Williams as a dangerous repeat offender. There was just one problem. Williams was already shaking his head. "That's not me," he said. "Here is where most defendants would have been steamrolled. A judge under pressure, a prosecutor confident in her paperwork, a courtroom moving fast through a packed docket. Instead, the judge stopped and asked the one question that changed everything: are we even talking about the right Kareem Williams? That single sentence is worth sitting with because it is the entire case in miniature. A courtroom is supposed to run on verified facts, not assumptions. Due process, the constitutional guarantee that the government cannot deprive someone of liberty without fair procedure exists precisely for moments like this. It does not mean a defendant gets to walk away from real charges. It means the state has to actually prove the charges belong to him in the first place. When the prosecutor admitted she would need to double-check, the confident wall of accusations cracked in real time, and it turned out there were two Kareem Williams in the system. Two men, same name, two entirely different histories, tangled together on paper in a way that could have cost the wrong man his freedom. Think about how often this happens outside a courtroom. A background check flags the wrong name before a job offer. A credit report confuses two people who share a name and a birth year close enough to trigger a false match. Most of us assume the paperwork is right because it looks official. Williams's case is a reminder that official does not always mean accurate, and that being misidentified by a system with real power over your life is not some rare glitch. It is closer than most people think. But the courtroom's honesty cut both ways, and this is where the story gets more complicated than a simple mix-up. Even once the mistaken rap sheet was set aside, the judge turned back to what actually was true. Williams had picked up a prior fugitive case in 2019. He had been granted bond twice before. Both times that bond was revoked.
Tell me.
So Judge Fletcher, he's wanted out of Beauregard Parish, Louisiana for home improvement fraud. At this time, the state's asking for no bond, based on the fact that he has a prior fugitive case, which he was granted 2 bonds on, and both were revoked. They were $25K and $65K.
We gave him a $65K bond and he made it and it got revoked.
And he had been gone, by his own account, since 2019, only resurfacing now because Louisiana authorities had caught up with him on the fraud allegation. You are a flight risk, the judge told him flightly.
Some skin in the game, and he knows he's going to lose it if he doesn't.
He was on the lam for this DWI. You're a flight risk.
Not as an insult, but as a legal finding, a determination that if released, the odds of Williams appearing for future court dates were too low to justify letting him go without conditions. Flight risk is one of the 2 central questions in any bond hearing, alongside danger to the community, and once a judge concludes it applies to you, cash bonds tend to replace personal recognizance releases, meaning you pay to guarantee your return instead of promising it for free. Williams pushed back the only way he had left. He told the judge he had lost both his parents around the same time as his original arrest, that his grandmother had just died in a house fire.
I'm really not, but I'm just asking just to be able to go take care of this. Like, I really do. I'm trying my hardest. You know, I just lost both. I lost both of my parents. When I got in that DWI at 19, my grandma had just died in a house fire. It's not an excuse. It's not. Oh, yes. So,
that he was not trying to run. The judge did not dismiss the grief. She acknowledged it directly and still held the line.
If I give you a bond, you will take off on me because I gave you a bond in the DWI. And the last time I saw you was in 2019.
I gave you 2 chances, she said.
2019.
Just my parents that died. I'm not making.
And I'm really sorry for your parents.
Give me another chance. I'm not.
But, huh?
If you give me a chance, I'm not gonna mess this up.
I gave you a chance. I've given you 2 chances. Fool me once, shame on you. Fool me twice.
Right. Fool me once, shame on you. Fool me twice. Should a judge weigh someone's personal tragedy against their record of skipping court? Or does that risk turning bond decisions into a referendum on who tells the most sympathetic story? That question does not have a clean answer, and it is worth sitting with before you decide who was right in that room. In the end, Williams did not walk free, and he did not stay locked up either. The judge refused a personal recognizance bond, the kind that requires no upfront payment, but set a cash bond of $2,500 on the DWI, along with the standard 14-day window once posted to begin resolving the underlying case.
So let's do this. I'll have you guys going back, talk about it, but I can't in good conscience give them a PR bond again. When we did that and he took off for 4 years, no, it doesn't work like that.
Understood.
It was not the clean vindication of the mistaken identity moment. It was not the walk-away freedom his attorney had hoped for either. It was something narrower and more honest, a system correcting one error while still holding him accountable for what was actually his.
Right.
Here's what I'll do, Judge. I was just appointed on this case today. There has been some criminal history thrown out that I was completely unaware of. Let me do my homework on this and reapproach with a better argument.
Can we appoint Ricardo and the DWI as well?
So what this case really exposes is not one villain and one hero, but a structure where confident, sounding accusations can move fast enough to outrun the truth, and where the only thing standing between a person and a wrongful record is whether someone in that room is willing to stop and ask the right question out loud. The paperwork will not always save you. Sometimes the only protection you have is a judge or an attorney, or you yourself refusing to let an assumption pass as a fact. If you want to see another real courtroom moment broken down like this, tell us in the comments which case or hearing you want covered next. Subscribe and share this video, because an informed public is the best defense any of us have against a system that moves too fast to always get it right.